My name is Paul Michel. I'm going to serve very concisely as the moderator of this panel of distinguished scholars and activists. If you've surveyed your program carefully, you'll see that the title of this 90-minute session is, quote, minimizing risk and maximizing reward, intellectual property as regulatory policy or property right. So as is often the case, you can ignore everything before the colon. The real subject is it regulation or is it property at bottom? I'm pleased to be moderating this panel. I will not try too hard to keep it moderate because we probably want to have lively debate and diverse viewpoints expressed. So maybe the title moderator is slightly off. We certainly have a stupendous panel. We're going to proceed, you know, it's a little bit like courts. In courts, in order to avoid friction and trouble, everything is done by seniority. So since we can't use that principle here, and since it's not a court, we're going to use alphabetical order. So the fact that our distinguished panelist, Gigi Sohn, is going to speak last is simply an accident of alphabetical placement. First, we're going to hear from Professor Richard Epstein. Some of you may be old enough, maybe not, but I certainly am, to remember a very lively debate in this very ballroom of the Mayflower Hotel about 10 or 15 years ago between Richard Epstein and two-time White House counsel Lloyd N. Cutler.
Oh, Jesus.
And for those of you who remember this, Mr. Cutler was outgunned 3 to 1 on word count, and many felt in other ways too. So since then, Richard Epstein has written about 10 more books and has shifted from his prominent perch at the University of Chicago Law School to become the first and only Laurence Tisch professor at NYU Law School over the last couple of years after visiting there for a while. Many of you know him. He's a frequent appearer here at Federalist Society lawyer meetings. I don't want to spend too much time on his background, but one thing you may not know is that in addition to graduating from Columbia, Yale, and Oxford, he also holds an advanced degree from the University of Ghent. I think that's in Belgium. So the one thing I want to highlight particularly for you in terms of Professor Epstein is not past but future. He has a book coming out shortly which will focus on property rights, the very subject of our panel today. Next, I want to tell you just a little bit about our other distinguished panelists. So we're going to have a lot of fun hearing from Brett Frischmamn, who's now at Cardozo Law School after some time in Chicago. Seems to be a common theme. Also, I believe, a Columbia graduate, so other common background. He's an expert in internet law, among other things, and that will be part of the scope of our discussion today. Professor Mark Schultz is at Southern Illinois Law School after a distinguished career in private practice. Gigi Sohn is known to many of you. If you watch CNN or read the New York Times or are awake and alive in America today, you probably have read her, seen her, heard her. She is the founder and leading light of public knowledge, and so is very deeply invested and knowledgeable about other ways of organizing access to knowledge and learning and the legal overlay of all that. So, Professor Epstein, is it property, or is it regulatory policy, or is it maybe something else?
How many minutes is this again? 3 to 5?
Well, let's shoot for 5.
Okay, 5 minutes. I think the answer to this question is it's a hybrid. 90% property, 10% regulation is about the right proportion. And let me see if I could explain why. I think the best way to understand intellectual property is to understand something about the broader class of property relationships. And then once you understand that, generally, you ask the question, how ought that to be adjusted and fitted to the somewhat but not entirely distinctive features of intellectual property? And if you start going with respect to the key rules with respect to standard property, I'm going to summarize them very quickly. The first one is you have a private rule of decentralized acquisition known as the rule of occupation or first possession, and that is usually leads to the proposition that possession is prima facie ownership of property in fee simple. Once you own this property, the question is, what do you own? And the usual rule with respect to land and chattels is there's no reason to make the ownership shorter than the entire fee simple, so that what happens is the property rights are presumptively of indefinite duration. Simply having property and the right to exclude doesn't do very much for you. You have to have the right to use or to practice a patent, as we would sometimes say. You also have to be protected against use by others. That's what exclusivity means. And you also have to be able to secure gains from trade by either sale or by licensing. And the feature, therefore, that you look for most is a way, essentially, to try to increase the velocity of transactions by reducing the transactions cost through such devices as the statute of frauds and a recording system. And if you just actually take this system around, there are a few little errors, and then you need to figure out how you correct boundary conditions and other things of that sort. But this is an amazingly durable system. The question then is, how does it carry over with respect to intellectual property? And the answer is it's going to be a little bit trickier because the ideas that you're trying to deal with are more elusive and they're not tangible in the same way, but you nonetheless can get pretty far down that road. And the first thing you do is you have to figure out what you want is a rule of private decentralized acquisition or some public central thing. And if you're a good property lawyer, you say, nope, I'd rather have people file claims and define their boundary lines, at which point the central task, which is a central task with respect to land, is to figure out which of those things are common property that cannot be owned, like the air, and which of those things are private. And certainly you want to have the rule that general rules of knowledge and general physical laws are not something subject to patent. Once you have this particular patent, then the next question is exactly what is the payoff with it? And in order to do that, what you have to do is to look at the 3 dimensions that I've talked about before and see the way in which they start to play out. And the greatest difference, in my view, is on this first dimension, namely the dimension that we expect the particular intellectual patent right or property right to be infinite in duration. When you're dealing with intellectual property, particularly when you're dealing with patents, that turns out to be a suicidal position because intellectual property has a feature which physical property does not have. In physical property, for example, if I own land and after 20 years it goes into the public, it means that there's a free-for-all and the thing becomes completely useless through overconsumption. On the other hand, if an idea goes into the public nature, each person can use it without preventing anybody else from using it, so that what happens is restraints on the ability of people to do this particular alienation will necessarily reduce the total amount of the thing that's done. So at the back end, we would like to have wider dissemination. But if you make it, say, patent, say, 1 second long, nobody's going to make the invention in the first place. So the question then always is exactly what's the optimal length of a patent? And my view is that you're probably not too far from wrong in most of the areas where it matters if you give this thing something like 20 years. You will then have to make adjustments, as under the Hatch-Waxman Act, where, in fact, if you have to patent something before you could get it through a regulatory authority, the entire value of the patent will be dissipated unless you allow somebody some extension off of that basic term. Because, again, the exclusivity at the front end is what drives the creation of free goods, or in this case, generic properties or generic medicines, at the back end. So what you do, in effect, is you try to develop that system. You got a few little wrinkles here and there, but essentially it's the right intuition with respect to this. And then what you have to do is you have to worry about the 2 other features of patents. One of them is exclusivity and use, and the other is the feature of alienation. And if you take this seriously, you will probably think that once you've made the adjustments with respect to term, there's no reason why it is that the traditional rules that deal with the injunction and the licenses should not carry over pretty much bodily in dealing with the various areas associated with patent protection. So if I wanted to figure out two black marks on the current patent jurisdiction, one of them would be the eBay case with its rather cavalier treatment of injunctions, and the other would be the Quanta case with its rather cavalier and I think somewhat uninformed view with respect to licensing. And so let me, in the time that's remaining, say a couple of words about each of them. With respect to the eBay case, I think the correct rule was the one that used to be in the Federal Circuit, which is there's an overwhelming presumption in favor of giving the exclusive remedy unless there's something that the patentee, by way of laches or delay, has done to deny it. There ought to be an exception with respect to tiny patents, which are part of larger mosaics, but it should not necessarily be a damage remedy. I think one of the things that the courts have neglected in this area is the simple view, which is used in all land cases, of simply delaying the enforcement of injunctive relief for, say, 6 months so that people can either bargain or design around the particular patent, rather than simply saying it's going to be a pure damages. So a mixed system of remedies, which is common in the land cases, should carry over to this situation. If you don't do that, what will happen is you'll get to this very strange situation where if for some reason you decide it's not optimal to practice a patent, immediately it becomes a free-for-all. And the difficulty here is quite simple. If you can have an unlimited number of intruders with respect to your space, you're going to have to bring an unlimited number of damage actions under a set of formulas which, to put it mildly, are less than informative, whether you look at the benefits received by the wrongdoer or the burden suffered by the particular owner. And what the whole point of an injunction does is it stabilizes the property relationships so that when you do issue voluntary licenses on either an exclusive or a non-exclusive basis, the people who are getting know what they're getting because they don't have to worry about further competition. And I think the Supreme Court's lack of understanding of how property was put together on that case has to be somewhere between stupendous and monumental. They simply do not understand how property systems work, and it's the general problem of the Supreme Court. They're there for federal courts and they're for constitutional law. Property is just too unimportant for them to put their great minds to the issue. When it comes to the issue of licensing, it's exactly the same thing. The correct rule with respect to licensing is pretty simple. Generally speaking, all licenses in whatever forms ought to be presumptively acceptable. The only constraint in this particular area that really matters is whether or not the licensing agreements or the cross-licensing agreements or the pooling agreements of one sort or another create a genuine antitrust risk. When you look at these cases, for once the Justice Department did a fine job when it said that pooling of complementary patents is perfectly okay to overcome the double marginalization problem, but pooling of substitute patents is in effect a way to create cartelization, and so what we do is we handle it on that sort. What happened with respect to the Quanta case is it dreamed up the exhaustion rule with respect to this issue, and so it made it very difficult to enter into complex licensing arrangements. In fact, in the particulars of that case, it's very instructive. The reason why LG wanted the peculiar form of license that it had with respect to its own trading partner was that it knew that when it sold it out, please just give notice to somebody else, don't collect the fee, because some of these people have already paid us to begin with. And so when you have these overlapping licenses, this is simply a way of making sure that people who have paid once don't have to pay twice.
I think we'll have to declare that the red light is on,
okay,
as we say in appellate courts.
One sentence. And so when you get this thing wrong, what happens is you create massive misallocation of resources, correct that, and all will be well. That was what I had to say.
Thank you. As you can see, the machine gun delivery has not lagged in the intervening decade since the incident I described. You also might observe that, like a great opera singer, he doesn't need to take a breath at any point. Next, Professor Brett Frischmamn will give his perspective on this same basic topic, and then we will have a kind of a free-for-all between and among the five of us once Gigi has finally had her turn at bat. Brett.
Okay, so I will not be able to say that much in 5 minutes, but I'll try. In my view, the labels thinking about intellectual property as either property or as regulation is a bit confusing to people because they're at best partial metaphors. So in a sense, I kind of agree. It's a mixed regime, whether I'd call it 90-10 or something more like 70-30, 60-40. We can talk about later. But so I would see the split a little bit differently. But, patent and copyright are somewhat analogous to land grants, and patent and copyright laws as legal systems are somewhat analogous to regulation or other systems of regulation. And I suppose the relationships established among patent owners and the public, can be thought of as partially analogous to franchise agreements. So I think that, the question of whether IP is more like property or contract law or regulatory policy, the question is, it's all of the above, and the difficult questions that we face in IP are almost always about institutional design and how to sort of deal with the contours of the intellectual property system. The problem, though, I think with looking for the right label or the right metaphor is that it's often mistaken as complete when it is, in fact, partial. So exclusion and alienability certainly are features of property and intellectual property, yet non-exclusion and inalienability are also features of intellectual property. Right? So patent and copyright systems, as I've sort of argued in a bunch of different articles, construct semi-commons arrangements which involve both private rights and public commons. And they play a pretty important role in constructing what the public commons looks like. The property metaphor is partial because, as Richard explained to some degree, the underlying resources are different. Right? So private goods that are rivalrously possessed and consumed must be allocated on an exclusive basis. That is, alienability is essential to effective market allocation, right, to allow the resource to end up being possessed and consumed and used by the person or entity that values it most. But intellectual property concerns public goods that are non-rivalrously possessed and used, right? They can be possessed by many at the same time, used by many at the same time, and repeatedly over time. This technical characteristic of the resources governed by intellectual property systems means that there's an extra degree of freedom. The resources need not be exclusively possessed and consumed. They can be shared non-exclusively, nor is a market-driven search for the highest valued use necessary. Of course, it often makes sense to do so, and there are advantages, utilitarian or instrumental advantages to doing so, but they need to be evaluated in context, I think. So allocating non-rival resources subject to intellectual property to the commons, or even partially doing so, as we see done more in copyright perhaps than in patent, is an important function of intellectual property systems. Now, is this property or regulation? I think you can call it both, right? You can think of it as a sort of a common property and a private property regime mixed, or you might think of it as a regulatory system in another sense. Now, of course, for rivalrous goods, exclusion and alienability are necessary, but it's not the case it's necessary for non-rivalrous goods. There are other technical distinctions that matter, including, for example, the fact that intellectual goods, intellectual resources tend to be more often part of complex cumulative systems, right? We stand on the shoulder of giants is not only sort of a metaphor for the fact that we stand on the accomplishments of past generations, but even within our own generation, we're consistently, every day, engaging in that sort of cumulative building process, where we're all contributing value as we are expressing ourselves and generating new kinds of knowledge. But the basic point, I think, even putting aside some of the other technical distinctions that I think matter, the basic point is that the metaphor to land or chattel property is partial and incomplete. And so patent and copyright law mix private rights and commons precisely, I would argue, to leverage the non-rivalry or that extra degree of freedom that the resources by their nature provides. Of course, private rights play a really important role. That the right to exclude is important in intellectual property precisely because it facilitates markets, both draws private investment and funds into the creation of the original thing, whether it be the invention or a work of authorship, but also the stream of downstream markets that flow after that. And it varies based on context, whether you're talking in copyright or patent. The degree to which commercialization depends upon the property right itself. But the basic idea is that you're relying on the construction of markets or the facilitation of markets to overcome persistent supply-side market failures. But it's important to keep in mind that exclusion is a result of government intervention, right, into what would otherwise be an open, competitive, and joint use of an intellectual or non-rival resource, right? So I think that the baseline position is one that you could say that argue exclusion ought to be seen as an intervention that should only be thought of, ought to be entertained only to the extent that it's necessary, or in other words, justified by the need to fix these supply-side problems. In a sense, as Tom Bell has written quite a bit about, right, you can think about it from a very libertarian perspective as intellectual property being a fundamental deviation or government intervention into our ability to express ourselves and use what would otherwise be in the commons. Now, one way, what this gets at, I think, is that Richard and I are probably in very similar positions when it actually comes to institutional design questions. But our baselines, our default starting point may be a little bit different. So, you know, in the end, through rational discussion, I think we end up sort of converging on a middle ground. One of the points I would say, so I agree in terms of some of the black marks in the patent system that Richard suggested, although with the eBay case, I think maybe it's a big problem, maybe it's just it's a much overstated problem, because in practice we'll end up with a rule that largely grants injunctions, except for in some rare circumstances where a small component leads to hold-up problems, in which case we're sort of, again, we converge to a very similar position. Now, the one thing I would say, though, is if you want strong patents, you got to have better quality, I think. I mean, I think one of the things that, you know, if the boundary problems, the fact that you have complex overlapping resources and you're trying to think about how to assign rights to them, it's easy as a simple matter to say, if I contribute something and I've added value, I should have rights in it. But and that may be easier to handle in sort of some rival goods, tangible goods situations. But in the intangible context, in the intellectual context, there's often multiple inputs coming from multiple different places and multiple outputs, and it's just a very complex system. Drawing boundaries can be quite difficult. It's sort of the struggle in copyright and in patent is often, you know, when you're teaching these courses, much of what the struggle is about is understanding these doctrines that try to say what's in the system and what's not in the system.
Can you wrap up?
What's it? Wrap up? So it's easy to say, oh, well, abstract ideas and fundamental scientific principles should be out. But it's very hard in copyright, for example, to say what constitutes an idea, right? So it's a real struggle to sort of determine how those things get, how those lines get drawn. And I think that's really where there's a lot of work to be done.
Thank you. I think that the pace set by our lead runner, Professor Epstein, in terms of words per minute is being well maintained by his successors.
Yes, Brett's an old friend of mine. I never call him when I just have 5 minutes to talk.
Don't worry, you'll get equal time, Mark. The floor is yours.
So the question for me is how do we best reward and protect the products of intellectual creation? And that's where the regulation versus property question comes up. Certainly, we use both modes of regulation and property, and a country can choose to have an extensive cultural policy, an extensive industrial or innovation policy, or it can use property rights more extensively and rely upon those to reward and encourage innovation and creativity. And from my perspective, I would contend we should prefer property rights. Here are a couple benefits of property rights generally, and then I'll tell you why they're particularly important with respect to the things that are the subject of intellectual property. Property is both an effective institution and a liberating institution. It's efficient because it delegates control of resources to those who have the best knowledge and information as to how to use them effectively, how to employ them in ways that benefit individuals and benefit society. And government can never compare. When you centralize control of resources, you get too far away from users, from creators, and too far away, and you lack too far away from the point of decision, and you lack sufficient information about how to use these resources well. Property is liberating because it protects and encourages individual freedom. It's no mistake that Enlightenment thinkers and our founders put life, liberty, and property together, and in that order quite often in their rhetoric and discussions. Without property, without control of assets, without control of the product of your labor, it's very difficult to be free and ultimately to live. When you owe your existence to others, you have no independence or no independent judgment. So these are reasons we can like and prefer property as an institution. And I would contend that with respect to creators and innovators, these considerations apply and are important. They need property rights just as much as anybody, and sometimes more. Inventors and artists, authors often challenge the status quo. An inventor will often disrupt settled industries that have political power. They'll often challenge the status quo in scientific research. And in order to proceed, in order to create and invent, they need a certain amount of independence, the independence that property rights helps give them. They have something to bring to the table and to use to transact with potential investors and customers. And I'd say the same is true with artists, with filmmakers and authors. They often have a disruptive message, or if their message isn't disruptive, they don't have to be an avant-garde artist. They may just be simply too lowbrow for the preferences of those who would like to mandate culture. They don't have the proper message. If you look in countries where the arts are subsidized, what you tend to find is perhaps not necessarily even a high degree of political interference, but a high degree of bureaucratic interference. In Germany, for example, they tend to subsidize art that is either traditional German operas or avant-garde art, but it all demands that people channel their energy and creativity into certain bureaucratic channels. They lose their independence because they need to rely upon others for their living. And so because of this vulnerability, intellectual property rights help give these artists, these creators, innovative people, creative people, the ability to exist independently, to earn a living, and enjoy a living apart from government subsidy, apart from patronage. And they only need satisfy customers in the market or a small group of inventors, not an expert panel of people in their field of science or a government panel that mandates what kind of art is proper or what kind of art reflects national culture. So I say that while we're a rich country and we can afford certain subsidies, we can afford a certain amount of cultural and innovation policy, we should always first and foremost prefer property rights because they are most effective and liberating. Thanks.
Thank you very much. I'd like to just jump back a little bit, having plugged the upcoming book by Professor Epstein. I want to also highlight the fact that Professor Frischmamn also has a book coming out shortly from Yale University Press, which will deal with the relationships between infrastructure resources, property rights, commons, and spillover. So two important books in this field. And with respect to Professor Schultz, like Ms. Sohn, he has a strong international dimension, which of course is very timely since it really is becoming more and more every day a global marketplace, and entities here and elsewhere have to compete across international lines, not only in terms of sales and market share, but also in terms of intellectual property regimes. I also note that Professor Schultz spent 8 years in private practice before he went to the academy, so presumably that greatly enriches his perspectives. Like Professor Schultz, Ms. Sohn has a very strong international dimension and has been active among many other academic institutions with the University of Melbourne, which of course is in Australia. So, Ms. Sohn, the floor is yours.
It's a long commute. Anyway, thank you so much for inviting me. Thanks to Federalist Society. I think this is the third or fourth time I've spoken in the last several years, and I'm sort of the favorite moderate to liberal on intellectual property and telecom issues, and I do appreciate being here. Though I will say it's going to be somewhat ironic that I'm going to be the only one here quoting the Constitution. I'm going to be the Clarence Thomas originalist here. That in Article 1, Section 8 of the Constitution says that Congress may act to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So what that says to me is that IPRs, intellectual property rights, should be considered what our founding fathers wanted them to be. That is, limited rights intended to advance a particular purpose, the progress of science and the useful arts. So in their purpose, in their limitation, and in their non-rivalrousness, which we heard several of the speakers talk about, Copyrights, trademarks, and patents are not like cars, real property, and guns. Now, of course, that's my ideal, but that's not the reality. And let me tell you what the reality is. Our IPR system, and particularly I'm going to focus on copyrights. I know what the eBay case is, but much beyond that, I'm not much of a patent expert. Our copyright system has become a regulatory morass that really serves few other than the largest media conglomerates who are seeking to maintain their outdated business models. Doesn't necessarily serve the artists, the small artists particularly, doesn't serve the public, and while it may occasionally advance the progress of the science of useful arts, I would say just as many times it serves to stall innovation and creativity. So how did this happen? Well, starting in the 1970s, and even a little bit before, these large media conglomerates decided that the best way to enforce their so-called property rights was not to go after the thief, all right? It was to go after the device manufacturer or the person running a service, a telephone service, a video service, that could be used to infringe for the misconduct of others. And while copyright law had already started spinning out of control, you had constant extension of terms, you had extension of copyrights to things like furniture and buildings and sound recordings. It was this decision to expand what we call secondary liability, first through the courts and then through the legislative process through laws like the DMCA, that has really turned copyright into a regulatory system in serious need of repair. So in the property world, the gun manufacturer is not liable if someone shoots somebody else with a gun. The owner of a private road is not responsible if somebody commits a robbery on that road. This is not so in the IPR world. In the IPR world, government forces private actors to police the rights of private actors. And that's a regulatory system, and one, as I said before, which I don't believe works. And it's particularly getting worse in an age where the subject of liability, that is the copy, is made every time a digital technology is used. I mean, we really have sort of a pre-VCR copyright law that's trying to be applied in a post-YouTube world. So I want to give you an example ripped from the headlines, ripped from the very recent headlines. I handed out a briefing paper, which you can find on our website, www.publicknowledge.org. Just 3 hours ago, the Senate Judiciary Committee marked it up and voted out of committee the Combating Online Infringement and Counterfeits Act, which goes by the sing-song name of COICA. So what does COICA do? COICA authorizes the Justice Department to bring in rem actions against domain names of websites that are, quote-unquote, dedicated to infringing activities. So the cause of COICA is just. There are websites, particularly offshore, that are wholly dedicated to selling the consumer, without their knowledge, oftentimes, downloads of movies that are first-run movies that are clearly infringing. However, COICA does this in a way that really would have made Rube Goldberg proud, and which truly, and I would say in contrast to the other issue I talk a lot about, net neutrality, truly would regulate the internet. So let me tell you how it works. So once a court issues an injunction against a domain name of a website, the DOJ can serve orders on a whole host of internet intermediaries, including domain name registrars or registrars, internet service providers, financial services providers like Visa and MasterCard, and advertising networks. These entities would then be required to discontinue providing services to the website. So for example, a domestic domain name registrar or register would be required to suspend and lock the targeted domain, taking it down for the world. Alternatively, ISPs would be required to interfere with DNS requests for domain and payment networks, and ad networks would be required to stop doing business with the site connected to the domain. So what you have here is a prior restraint. The website will not load, even though one might request it. And by the way, when you go after a website, but you go after the domain name, there are oftentimes multiple pages, web pages, on one domain. So you may be going after one website that's infringing, but there may be 100 web pages, and so you may be actually taking down 99 legitimate pages to get to the one. And this is all without due process. So neither the website owner nor the intermediary has any ability to show that the website is not infringing prior to being shut down. Now, this is further exacerbated by a section of the bill that provides a safe harbor from liability for a domain name registrar or ISP that voluntarily blocks domain names of websites it reasonably believes are dedicated to infringing activity. So let's set aside the difficulty of determining what is dedicated to infringing activity, okay? Why would an ISP take the chance of losing that safe harbor? So you can just see the scenario. Viacom goes to Verizon and says, that YouTube is full of music videos that infringe. Take it, block it. If you're Verizon, you may be faced with liability. Now, we don't know what the liability is. It's not in the bill. But just to protect yourself, you're probably going to take it down. You're not going to take that chance. So in the briefing paper, I describe other reasons, other unintended or possibly intended consequences of COICA. It invites, for example, it invites international retaliation. It threatens the stability of the internet by encouraging users to take the easy step of switching from their ISP's domain name services to offshore domain name services, making cybersecurity harder. But it's just to make a point. I really could go on, but I think you understand that U.S. copyright law is, and may well become even worse, a regulatory system where the government forces innovators and conduits to be the copyright police for major media companies. Proposals like COICA, or mandatory copyright filtering, or mandatory 3 strikes, where an ISP is supposed to force to kick off alleged infringers based on the allegations of a copyright holder, would make it worse. I've got some big or small ideas for how to make the system better and get more to what the founders intended, but it will take a lot of work and a lot of political power, which I'm not sure public knowledge has, but we're certainly willing to give it a chance.
Gigi, were there hearings and did you testify?
There were not here, and that makes it even worse. So this is a bill that was written by Senator Leahy, who is usually a fan of cyber liberties, but in this case is not. There was a hearing, it's sort of an oversight hearing, where the new intellectual property enforcement coordinator, a wonderful woman by the name of Victoria Espinel, reported on a joint strategic plan that she had just drafted and published. And she mentioned as part of that draft strategic plan that these rogue websites are a problem. And said there was no discussion of any legislative language or what to do about it. She didn't even recommend legislation. She just said these sites are a problem. And Senator Leahy's staff said that was good enough of a hearing to move forward with a markup and a vote.
One might observe that although they masquerade under the same title of intellectual property rights, there might be thought to be very, very major differences between copyright law in practice and in theory, trademark law in practice and in theory, patent law in practice and in theory, and other variants of IPR, including trade secrets and unfair competition. So we should be careful to not necessarily equate these various fields. Richard.
Yeah, that's the point I wanted to address, and in the following way. One is, I think Gigi said something about trademarks, and those should be of infinite duration, and I don't think they would be created under federal law, and they are, because there's no reason to put them back in the commons because it destroys their value. But I would have thought, and I fought this very hard, I think one of the single worst pieces of legislation was the Copyright Term Extension Act of 1998. I regard this as another public disgrace. And the reason is that if you can shorten the term associated with a copyright to make it something sensible, it reduces all the other problems you have associated with its enforcement. The moment these things start going on steroids, so essentially the patent term exceeds, or the copyright term exceeds the useful life of the copyright, you're in deep trouble. If you had it shorter, then the question is, what do we think about secondary liability? And I would just make this following observation. I don't think it's accurate to make the problem quite as easy as you do. This is certainly not a case where you're holding somebody responsible for selling a tool which could be used in a burglary. But there is all sorts of derivative liability when the tool can only be used for a burglary and the guy who's selling it knows that the other fellow is going to be a burglar and so forth. And it's an extremely complicated question to decide whether or not you want to go after one distributor or multiple infringers. So to give you a provision that actually works is if you have a bunch of surgeons that are using patented procedures, it's silly to try to go after each of them individually. What you'd like to do is to get the person who is the ultimate distributor simply to reduce on transactions costs. So I don't wish to defend anything that Senator Leahy does, and on principle, I'm sure I'm opposed to it. But I think the point that really does stick is that if you try to do something like this without some kind of a hearing when it's such a difficult area, you're just going to get it wrong.
Mark, do you have a view?
I agree that although these, at the periphery, many of these issues, we have to be careful when we critique intellectual property rights in terms of particular legislation or particular cases where we're unhappy with the result, that we devalue the institution. With that said, I would actually agree with Gigi quite a bit as to the Modern Copyright Act. There are sections of it that read like the Internal Revenue Code, and they indeed are only known to a handful of people in industry who use them and benefit from them, and they were often negotiated, or most typically negotiated and drafted by industry. So in this respect, unfortunately, modern copyright law is more regulation, as Gigi says, than property right. I was struck, though, by what she was saying, that perhaps the solution is to make copyright more like a property right. And what we have to understand with respect to both patents and copyrights is there's often a debate over the metaphor. And when we say that copyrights and patents are property, are they property as sometimes people understand them, as an absolute right to exclude, a sole and despotic domain, as Blackstone said? Or that's a parody of property. Property is a highly constrained institution with a lot of rules surrounding and limiting it, and any property right is best understood that way in context, and indeed that's how we should understand intellectual property rights.
Brett?
Well,
and then Richard.
Sure. Yeah, I mean, it's hard to not agree with what Gigi said about Senator Leahy's bill. Right? It's kind of over the top, crazy, just a bad piece of legislation, I think. On secondary liability, I mean, I would just throw out this. I mean, the courts in sort of secondary liability is not in the copyright statute, right? It's not actually, it's not directly in the copyright statute, right? Judge-made law, and consistent with judge-made law in other contexts, right? It's exceptional, right? So the general rule, as you sort of learn in first year of torts, is, and as Richard could probably tell us in more detail, right? General rule is you're not liable for the wrongs of others, right? Except when you're in some special relationships, or there's some kind of special category that you fall into. And the courts develop contributory liability and vicarious liability in the copyright context, sort of on that mode, right? In general, you're not liable as an intermediary for the wrongs of others, for the copyright infringements of your end users, unless you fall within the scope of contributory liability or vicarious liability, which are sort of technical doctrines, but are relatively, I think, well cabined, standing alone. The DMCA, sort of to provide some, cover against the threat of increasing lawsuits, and at the same time to enlist intermediaries in taking down material once they're provided with notice of infringing material, have a sort of a notice and take down procedure, which is imperfect, is abused at times, many times by copyright owners, and yet, it's imperfect, but it works reasonably well, I think, and I think there's a lot of debate about this, given alternatives, and so there's still a search for what's the right way to enlist intermediaries in this process. But I think, then you've got the Grokster case in which the Supreme Court adds a version of contributory liability, sort of thinking about inducement liabilities, which to me sounds more like an intentional tort, where you're sort of intentionally inducing your users to engage in infringement. And so it's the gradual expansion, which I think we now see Leahy and others sort of looking for ways to enlist intermediaries and conduits in the policing of copyright.
Right. I mean, it's expanding it to where there's actually an affirmative duty to filter, okay, or this this voluntary conduct provision in the Leahy bill, which, isn't really voluntary at all, because you're damned if you do and you're damned if you don't. And that's really, I like the Sony versus Universal, as long as the technology was capable of substantial non-infringing uses, then it was, then it was legitimate, then you couldn't find the manufacturer liable. And the Grokster, well, at least Grokster footnote 9, whatever, turned that on his head and seemed to foreshadow a conduit or a manufacturer actually having to build its device or bake within its conduit a way to block infringing activity, which is impossible to do, by the way, without being overbroad, acting overbroadly. So that's the concern, and that's been obviously particularly in the last 10 years or so, that secondary liability has just grown out of control. And I think the DMCA started it, frankly.
Richard, back to you.
Yeah, I mean, on that last point, I've always been sort of uneasy about the entire Betamax type decisions because the error cost is so high in both directions. There could be substantial non-infringing uses of 5%, 95% infringing uses, and it may well be that you're better off shutting the system down and trying to find another way to serve the legitimate segment of the market. It's just real hard to do this on an a priori basis, which is one of the reasons why you have to have hearings before you do bills. The point I wanted to comment on separately, and I agree with that, I mean, is Brett's point about the question of do we treat all intellectual property as an exception to basic property systems. My former student is Tom Bell, and I taught him the theory of property. He didn't quite learn it the way I did, and let me see if I could explain what I think. It's a very profound conception. That is, the hard libertarian line on this particular point is that the moment you create a patent, you're limiting somebody's ability to use his own labor and his own things in whatever matter he or she chooses, so long as there's no fraud against another. And every time you create a copyright, you're limiting the freedom of speech. The justification has to be in social welfare terms, and I'm going to try to take what Brett said and sharpen it a bit, see if I could get this convergence thing going a little bit further, which is the way I defended it, and something I wrote in the San Diego Law Review some time ago, is that you allow for the limitations of ordinary free speech rights under the standard libertarian theories to the extent that you generate Pareto improvements. And in the strong sense, that means everybody in the ex-ante position is better off than worse off, and all of the arguments that you see about innovation for invention and creativity in the arts are basically trying to make that. And if you do it at an early enough stage in a general enough form, it's hard to see a systematic distributional skew if the overall gains are large. The problem, of course, is how often can you go to the well and play the same trick. So just to give you an idea of how difficult it gets, in the copyright area, we do this stuff and then immediately we say, whoops, and you start thinking about fair use exceptions because it turns out now you're stifling criticism. And you just always have to vary. Every variation off the previous baseline should be tested against this particular standard. And you should do it both in copyright and in physical patent copyrights, patent areas. And this is the conclusion you generally reach. Since the copyright invokes issues of free speech and the like, I'm more willing to think about exceptions in that thing than I am, generally speaking, in the patent area, where the only things that you see of free uses are indeed free rider effects. But that's the methodology, I think, that should drive what Brett said and explain why it is that the Tom Bell, who's trying to write this up into book form right now, is, I think, going arguably down the wrong road.
One observation I would interject into
Brett
our
here.
discussion is that the enforcement of any one of the IPR rights is obviously divided between regimes legislated by the Congress and judge-made law, as was mentioned earlier. And it seems to me, at least, a little bit ironic that in the context of recent year consideration, for example, in the Senate Judiciary Committee on patents and going back a little further on copyrights, I don't recall that there was any attempt to coordinate the role of the judicial branch with the regime being created by the legislative branch. So, for example, in the patent reform hearings that were pursued in successive Congresses for 5 straight years, to my recollection, not a single judge, trial or appellate, who enforces patents was ever called as a witness, and almost no litigators were called either. So maybe there's a little bit of an inter-branch disjunction here, and they need to be a little more collaborative.
I think that's what happened around the 1976 Copyright Act. I think at the time Congress and the Copyright Office itself were looking at how fair use was developing as an exception to copyright law and incorporated that in Section 107. But I agree with you 100% on the patent reform bill, and certainly on this bill that Senator Leahy has proposed.
We may have unanimity across the two tables among the five of us that we need Congress to do better work.
Well, you know
Or
what?
no work.
You know what I'll say though, and this is very cynical, but following Fred McChesney's work on legislation, and what legislation often is it may be a milker bill, which what Fred calls a milker bill is a bill that's put out there not because they want it to become a law, but because it's a signal. Contribute now or this horrible thing may happen to you. And I think that may be one reason that patent reform, for example, hasn't been consummated, because it's been incredibly lucrative in terms of campaign contributions over the last several years. You have all these powerful economic interests donating like crazy to try to influence the process. And although I respect Gigi's indignation at this bill, and I'm glad there are groups out there to fight this bill, I have a feeling the interests, the ISPs can take care of themselves and will indeed pay up as they need to. So I'm not so worried.
Of course, legislation to the highest bidder isn't necessarily the best legislation.
That was the McChesney point, in fact. I mean, I published that article, and then he wrote it in a book called Money for Nothing. And the title was designed to say you pay to get back to the status quo, and if everybody does it, all you do is you spend a lot of money spinning your wheels, which is why Congress is down at 11% popularity, and you wonder not what's wrong with the 89, but with the other 11.
Now, we endeavored in our planning to be sure there was adequate time for questions from the floor, and we are about at that portion of our time together. So while I don't mean to shut down any of the panelists, if there are questions from the floor, I will consider them in order starting now.
Look on the left.
There we go.
Yes, sir.
Hi. So as a law student, I'm struck that some of the perspectives I see here are somewhat different from what Professor Ochoa teaches me out in California. And I'm wondering what the panelists think of the Ninth Circuit's position on the first sale doctrine and the Autodesk and eBay case. And if you guys have any thoughts on how that seems to be moving around out there.
Is this an exam question you're looking for help on?
No.
Not yet.
Was that the record case, the Augusto case or something like that?
This is where the guy was reselling old copies of Autodesk software on eBay, and the Ninth Circuit is trying to say the EULA would override first sale.
Yeah, we filed an amicus brief in that case. Obviously, we weren't happy with that decision. And this really sort of plays nicely where I was talking about how we have a pre-VCR copyright law, with the exception of the DMCA, largely written in 1976, that's trying to, you know, fit into the real-world realities of digital technology. What does it mean to license software? Do you own it? I mean, what does it mean to own a digital copy? What does it mean to own a digital copy in the era of the DMCA, where you can't break technological protection measures even after the forever copyright term runs out?
Anyone else?
I think it's something the courts are going to have to continue to grapple with,
Yeah.
but I think they were on the wrong side of that one.
I have reactions, and I don't know the case well enough to speak authoritatively about it, to put it mildly. But let me talk about the more general question here as to whether or not you wish to conceptualize these transactions as sales so that they're caught by the first sales license, or licenses so that they're caught by the freedom of alienation license. My view about that is a freedom of contract type position. What happens is you've got two extreme forms. If you wish to put this in the form of a sale, such that the thing can now be resold, what you're going to have to do is to pay some kind of a premium. If it turns out that you put this thing in a license with restrictions on resale, then presumably you will get it for something of a lower cost under these circumstances. From the ex-ante perspective, I'm really not exactly sure which of these two arrangements turns out to be optimal as a matter of abstract thought. But if you actually look look at the way in which these rules tend to work, what happens is that people are very suspicious of the resale and tend to want to do the license. What makes this case a hard one, just listening to the discussion, is the thing that obviously somebody's absolutely frightened about is you put one of these licenses out, they're told that it's not binding, and what you do is you make a zillion copies and you sell each of them to somebody else, and at that particular point you're in a different world because you've killed 5 future sales. If it's just a question of taking a single item and selling it from one person to another, like a book, for example, I have a very different point of view. So that the real question in these particular cases may be that the correct response, if you're thinking about a regulatory impact, is that you can sell so long as you do not multiply, but you cannot sell if you're going to try to use it with respect to multiplication. And if that were the only stake of the issue, I think price adjustments would be able to work pretty well. If multiplication is there, there's no front-end price which will allow you to accurately hit the fellow who wants to keep it for its entire useful life and the other fellow who wants to make an entire business of it.
Next question.
I'm wondering, both Brett and Richard spoke of the problem of quality. In fact, I think that's a point at which they rubbed elbows. And it goes to also Richard's comment that if, in a sense, if the quality of copyright law were improved, there would be less problem about respecting a more restrictive and property-oriented orientation of enforcing it. And for lack of a better metaphor, if I could look at obviousness in the patent realm as kind of that question of just acquisition from nature, if you will, in a property sense, I mean, I do think that respect for the intellectual property regime is undermined by the anecdotal cases, by the peanut butter and jelly sandwich, by one-click ordering. I mean, my mom cut the crusts off of my peanut butter sandwiches and squished them with forks when I was 5 years old.
Can you frame a question?
And the question is would the respect for intellectual property or that metaphor be improved if we improve the quality of obviousness decisions?
Let me just throw out I'll give you a quick answer, and I know Richard has something to say more that may be more on point. I would say that when I'm talking about quality, I'm more concerned with reversal rates, right? And I'm more concerned that invalidity, that you got a 50-50 shot in terms of whether it turns out that your patent's actually good once you get to litigation, as opposed to the peanut butter and jelly sandwich, right? There's a lot of worthless there's patents on things that are not worth much, but they're insignificant. And so if someone wants to spend money filing for a patent application on something that ends up being insignificant in the marketplace, and that may not really matter all that much, for how to teach your cat, exercise your cat with a laser pointer, right? One of the ones that we like to talk about. But, that a lot of patents that are over useless things, but nonetheless that would satisfy the patent criteria, I don't find to be that much of a problem. When I'm talking about quality, I think more in terms of we just don't really know if a patent's actually a good patent until we've actually gone all the way through litigation and find out.
Yeah, look, I'm going to say a slightly different form of this, but when you mentioned obviousness and patent quality, I think the issue with respect to patent quality is, do you know what's in and do you know what's out? It's a claim definition question, and that's absolutely critical. The obviousness element is somewhat different from the precision element, because what it's trying to do in a perfectly sensible way is to say, patent monopolies don't come cheap. You have to make the kind of advance over the pre-existing art, which is not just merely incremental, that any Joe Blow can do on his day. And that's why what you have to do is to say non-obvious to a person who's skilled in the art, as a sort of a standard. It's going to create all sorts of difficulties at the margin in many cases, but I don't think that those are the kinds of things that will defeat the system. And the test would be, find a better phrase of words that you can put together than the ones that Giles Rich dreamed up when he put together the 1952 Act. I don't think that you can really do that. And the last point that you mentioned is, I think, a very dangerous point, which is there have been some suggestions in the recent literature that what we really ought to do is to put beef into the utility requirement, so that we now want to bring some ex-ante judgment of commercialization and yield into the patent system. That strikes me as a complete disaster in terms of making patent courts, and I, with all respect to Judge Michael, I don't think he has a clue about industrial policy, and I would not want to put him in the impossible position of having to decide those those things any more than I would want to be it. But the answer to that is utility should be kept to its usual situation. It's not noxious. You're not trying to blow up bombs or things of that sort, and leave it to the system in that way.
Next question.
When we talk about theory and practice, I'm interested because there's a lot of discussion about public choice ideas and various capturing of Congress and its inability to do things. So can we really separate theory and practice, or would the actual practice of legislation ever change your idea about how we should actually do this? Maybe regulation is like in a perfect frictionless universe, okay, but it's not okay when it's done how it is actually done. Would anyone?
What?
Well, a
Thank God.
more regulatory system could only get worse. The further we depart from the property paradigm, the more involved we get in expert panels setting priorities, setting prizes instead of awarding property rights in order to encourage research in a particular direction. So the question is, sure, are there problems with the current system? Yeah, but what are you going to replace it with? I don't see a replacement that remedies the harms and problems you just brought up.
Yeah, just by way of an addition, one of the things is we have worked the other system, the industrial organization system. If you look at the history associated with the issuing of broadcast licenses in the United States, an overconfident and uninformed Felix Frankfurter back in 1943 in the NBC case said, when the FCC has a mandate to deal with the public interest, convenience, and necessity, it doesn't only set the rules of the road, it also determines the composition of the traffic, which was his word for industrial organization. We've now had 70-odd years, or 60-odd years trying to figure out what are the appropriate conditions for issuing licenses for the FCC, trying to use this stuff, and to say that they've come up with a ragtag, incoherent, incompetent, stupid type system is to praise lavishly the waste that's on there. And how do we know this? Because what the current rule is this: when the government issues a license, right, on some ridiculous local criterion, within 1 year the licensee can turn around and sell it off to the highest bidder, right? At which point you get the right allocation. And so the last thing you want to do, I think, is to treat that as the kind of pattern for the new age of patent regulation or patent design.
Next question.
This is about patent reform. Both the Congress and now I believe the USPTO is officially on board with this, moving from a first to invent system to a first to file system, or as Director Kapos calls it, a first inventor to file system. I know that there's some resistance towards this on constitutional grounds, that first to file or even first inventor to file would somehow subvert the concept of giving the patent to its inventor. Do you see that as having a merit? Or in other words, is first to inventor, first to file a regulatory issue or a property issue?
Hello?
Yes.
Fine. Yeah, look, this is actually something which is really very instructive. Let me go back to the 1830s for a second to give you some sense. The same issue arose with the question under the Contracts Clause, whether or not the first person to receive a deed from somebody else would be the winner, or whether the first person to file in a recordation system, if the other fellow did not, would win. And it was a very muddy opinion in terms of its logic, but the conclusion was indeed to correct. If you want to use the first to file system, because in the end what will happen is you'll reduce the uncertainty over title, such that from the ex ante perspective everybody is better off. And to put it in Contracts Clause language, this is not a question of whether you do or do not impair that first contract. Let's assume that you do. Is you've got the Pareto improvements that we talked about before. Everybody in the ex ante position is going to be in a better position to deal if they know that the writing is there. So when you come to this system, a first-to-file system with respect to industrial property has exactly the same virtues that it has with respect to land. And people start saying, well, little inventors, big inventors. And this is where bad sociology gets you into deep trouble. There is a myth out there, an urban myth, that somehow or other the little inventor benefits under a rule, which is, have you made significant steps towards invention and then file second, you could still prevail. The guy who wins under that is the guy with the big pocketbook, because they can play interiorum games. That means Intel, IBM, and all those fellows. Little inventors don't have a prayer under those rules. What you need at this point is a bright line rule, and of course there's no reason on the other side for not having that bright line rule. So far from saying that it's unconstitutional, if I had to do something silly on this point, I would say that the current system was unconstitutional, because if it does not, it fails to advance the learned arts and sciences and whatever it is. But in any event, we know from international experience there is not a single nation in the world that wants to move to the American system, and we should move to the other simple system. And I wrote a book 15 years ago when I spoke with Lloyd Cutler, who was hopeless on the day, that simple rules for a complex world is the applicable metaphor, and in this particular case it has a very clear and univocal answer to it.
It's interesting because there's a similar argument made in the copyright context.
Yes.
So under international treaties, you're not supposed to have formalities, so therefore, unless you want to get statutory damages, which is damages above and beyond your actual damages, you don't actually have to file for the copyrights.
Mess.
So whenever there is, talk about trying to reinstate formalities like registration, the MPAA and the RIA, which represent the big movie and record studios, say, well, that's going to hurt the little guy. But what happens is the little guy doesn't file. People, particularly photographers, is a perfect example. They get ripped off all the time because people can't find them. So it's a very similar situation. I think there are ways to get around Byrne. I mean, Larry Lessig has a great idea where you get your term of copyright, and then if you want any more, you get 50 years copyright, you want any more, you have to pay $1 and register. I think that would probably get around Byrne, but the elimination of required for registration has probably hurt the little guy the most.
Yeah, formality and regulations are very different things. Statute of fraud is a formality which enforces contracts because it makes it clear in the ex post state what happened in the ex ante state. And when people say, well, if you're going to concede the validity of a statute of frauds, you have to concede the validity of a minimum wage law, that simply means they don't understand how either of them operate.
Yes, sir.
Thank you. Hasn't the issue of whether we're dealing with a property rights regime or a regulatory regime already been answered at the practical level? For example, when a client comes to me and says, here's a patent, my competitor's patent, what does it mean and what do I do about it? I have to take into account the doctrine, rules of claim construction, the doctrine of equivalence, inequitable conduct, file wrapper estoppel. I sometimes feel like I'm acting more as a regulatory lawyer than a property rights lawyer. So as on the practical level, does the issue of property rights has that issue already been answered, or have we moved indeed too far into the regulatory regime?
You want to go, Mark?
Oh, well, I think I'm probably going to anticipate what you'll say, which is different property rights require different regimes, and some property rights are harder to define and determine than others. The rules regarding water rights are very complex and often hard to determine. It doesn't make it any less of a property right. And it's the paradigm and the approach that's important. The details are always complex.
Yeah, I will put it in a slightly different way. One of the things that is often missed by intellectual property lawyers is how complicated not only water law is, but land law is when you're trying to figure out what their operations are. Somebody has a claim with respect to land. You could have incredible differences with respect to the surveys and so forth. Does this matter? Well, there's a very interesting recent paper out by an economist named Gary Liability at Santa Barbara, and this is what the paper shows. If you describe your land by meets and bounds, and you've got some real numbers out there on a survey, it works fine. If you do it sort of by landmarks, one way or another, this goes up to the tree here, and then the river there, and then when the sun sets and so forth, the difference in market values, depending upon whether you have a survey or a description of the two parcels of land controlling for all other factors, could be up to a third. Because if you don't know the security of the boundaries, people are going to worry about, are you building too close to the edge? Banks are going to be worried about what it is they can and cannot foreclose and so forth. So you get exactly the same issues in all of these areas. The real question is, do you think that you're better off starting with a decentralized system of universal acquisition, subject to definitional problems on the one hand and individual forfeiture rights on the other hand? Or do you believe that what we want to do is to get some panel up there doing with respect to patents and copyrights and land what they try to do with the broadcast spectrum, which is start from the top? That is not a close empirical question. So what Mark said is 100% correct. What you want to do is cleanse the Augean stables of its various imperfections imperfections. You don't want to blow it up and then create something equivalent to the health care bill in order to deal with the patent problem.
Thank you.
Next question.
We have plenty of time, so I thought I'd throw a bomb or two.
Well, we got to get some digs in, come on.
There we go.
Richly deserved,
The
I
panel
might add.
took a turn at digging into Senator Leahy's bill. I'm not defending it in any way, shape, or form. That
Can
being
you
said,
get a little closer to the mic so we can
okay.
hear every word?
I'm not defending Senator Leahy's bill in any way, shape, or form, but I thought I'd throw a few bombs. The question is, when you see someone, anybody, House or Senate, dropping a bill this late in the Congress, it's not intended to make it through the system. It's intended to put forward a sense of Congress from that committee. In this case in particular, the Senate Judiciary Committee. It's a bipartisan bill. They're trying to do intent, and they're trying to throw a bomb in front of this audience and the courts. It's not going to make it through the House. It's not even going to get introduced in the House. So the question is, you guys wanted to bash it, but the intent of the bill is to actually precede the debate on the Telecommunications Act, which has the ISP carve-out. Gigi, correct?
I'm listening to you, but I'm not following, but I'm listening.
Okay. Well, the intent is to precede the new version of the Telecom Act, which the old one had an ISP carve-out. The intent is not to have an ISP carve-out to the next one. That's what Senator Leahy and Senator Hatch are trying to do. As such, if not that, then how are the property rights, the intellectual property rights, the copyright holders supposed to, continue to hold merit to their copyright? I mean,
Look, I mean, my view on this is I have taken no position substantively on this bill because, as I sort of indicated, I think the question of secondary liability is really very, very complicated. The problem when you get these rogue bills going through is not that they'll fail, but 1 in 10 times, God forbid, they will turn out to succeed. And that's what really gets lots of people very, very scared. I mean, let me just mention, I'm involved in litigation against the Durbin Amendment, and this went through in exactly the same kind of fashion that you're talking about here. Senator Durbin in May, with no hearings, puts through an interchange regulation bill, gives a functionally illiterate speech on the floor of the Senate, which nobody's listening to, explaining why it's a work of genius. The House decides that it's going to incorporate it because of the sage leadership of Marty Frank. And now what you do is you have a $50 billion industry completely in turmoil because the bill is so precise in what it says and so stupid in what it does that the entire thing has left an industry essentially tremoring. We're trying to knock it out on constitutional grounds. I hope we succeed. But I think this is exactly the kinds of stuff that we don't want our Congress to engage in. And we cannot get that if you don't have hearings. It's not enough, as Senator Durbin said, and other people will say in other forums, is well, we had a hearing on the interchange problem for 6 years already. Sure, you had hearings on it, but we never had a hearing on your bill, which is so far off the reservation that there's not a single person who disagreed with the other various proposals up there who would endorse this one if they knew anything about the subject. So I'm actually allergic at this point to these kinds of devices because I see the harm that they can do.
So this is just a matter, look, it's not a matter of whether, the copyright holders shouldn't be able to protect their copyright, whether these rogue websites are good or bad. It's the way that this bill goes about doing it. I mean, it goes about shooting an elephant with a,
No, not an elephant, yeah.
whatever.
Takes a rifle against an ant rather than a peagun against an elephant, right?
And it not only threatens to really destroy the way the internet actually works, but it also, threatens our goals in ensuring that there's global internet freedom. Secretary of State Clinton said very plainly, we want to ensure that all peoples, including peoples in repressive regimes, have access to an open and uncensored internet. If we start blocking foreign websites in Russia or Somalia or China, what do you think they're going to do to us? They're going to retaliate. I mean, it's just the method, and this is very, very typical of these copyright bills. It's let's see how much we can grab with both hands as opposed to taking a targeted approach. So a number of years ago, Representative Goodlatte from Virginia had an internet gambling bill that would have done many of these same things in the service of stopping internet gambling. In other words, make the ISPs and the financial services providers and others liable for internet, the activities of internet gambling sites. And basically, It didn't go anywhere for this very same reason, and what they did was they narrowed it down. They narrowed it down to cut off the flow of money to these sites. So we're not saying don't pass it at all. We're just saying in its current form, it harms free speech. It hurts the operation of the internet. It drives people to offshore DNS servers, so it's not going to work anyway. So why not try something more narrowly tailored that gets you to what you want? But there's also a larger point. This notion that you could somehow stop piracy is nonsense. It's nonsense in a digital world. It was nonsense in a non-digital world. I mean, remember, we were one of the first pirate nations. But there's always leakiness in the system. And at a certain point, you have to ask yourself, when do the companies actually have to change their business model in order to reflect the realities of a digital system? Finally, Brian Williams said the other day, I think people should DVR the NBC Nightly News. Okay, that was after 10 years of them trying to kill TiVo, and they did successfully kill Replay TV because they wanted everybody to watch TV when it was on and watch the commercials. All right, if they could have, they would have banned you from going to the bathroom during that time. So at a certain point, it's a balance of when do you actually say, look, people want to watch movies when they want to watch it. They want to stream them on Netflix and not 28 days after they come out on DVD, and they're willing to pay for it. So when are we going to make that content available, as opposed to greedily guarding it and going around punishing people or forcing ISPs to punish people?
It's possible that the U.S. Congress is both over-responsive and under-responsive. Over-responsive to major players with lots of money and big PACs and powerful bundlers, and under-responsive to the average citizens, whether they're TV viewers or whatever their other consumer interests may be. I think we might have both at this point.
Why not?
If only there were a way to find out what consumers wanted, but there is. It's called the market, and there's a price system. And although I'm with Gigi up to a point on the foolishness of some legislation, we shouldn't throw in the towel because there's massive piracy and you can never stop it all. There will always be some piracy, but this criticism of companies as if they're foolish because they're not doing what some advocates want them to do fast enough, I think it is unwarranted. We shouldn't, yes, they'll change their business models, but they need some reasonable expectation of a return.
It's not what advocates want them to do. Look at the market, all right? Look at how many people use digital video recorders. Look at Netflix is growing by leaps and bounds, all right?
Those are all private.
Right, but what I'm saying is it's not what me, the advocate, wants, all right? It's what their customers want. And they're basically, by having windowing, and you have to go to the theater first, and then the DVD, and then the video on demand. People are saying we don't want that. We want it now. We're willing to pay for it, but they don't want to make it available. They'd rather control than make it available. And actually, and when you control too tightly. That's when people say, if you're not going to give it to me now, I'm going to steal it. I'm not justifying that stealing.
Gigi?
Yeah, go ahead.
Yeah, but some of us, in effect, have a little sympathy for the companies. The partition of the market's an effort, as Brett whispered into my ears, to price discriminate between high and low demanders, and to the extent that you hit all things simultaneously, you can't do that. Nobody would want to say to booksellers, gee, you have to put out the paperback edition the same day that you put out the hardback edition, or that you have to sell at the same prices to libraries that you do anybody else. The way I would put the point is that on matters of entitlement, I think bright-line rules are the appropriate way to deal things. But on matters of remedies, what you said strikes a responsive chord in me, because sometimes you have to give up on injunctions and go to damages. Sometimes you have to give up on injunctions and damages and go to self-help. And the question is how you mix and match these three things together to try to get marginal equivalence is a much harder problem. Now, everything you said about trying to do the overseas number with respect to this site rings very, very true to me, but I think those arguments are actually a little bit weaker, and that's why I think Mark was pushing back on the second half, having to do with domestic distribution of intellectual property content, where under my view, if you have the right to own it, you have the right to sell it, you have the right to price discriminate, so long as you don't do it in cooperation with a competitive seller. Brett, you were going to say something.
Well, I was going to make the price discrimination point. I think in addition to that, I guess, is when you turn to Congress to create law to leverage intermediaries in order to facilitate your price discrimination, that's where there's a lot of objections, right? So it may very well be that your property right, if you have a property right, we're going to say you have the freedom to price discriminate if in fact you can, though I would, in other contexts, I would dispute whether we always want that rule.
It's complicated.
Yeah, it's very complicated. But, you know, I think the secondary liability point or the point of, you know, changing the law with respect to intermediaries is a slightly different one because you are, in fact, trying to pull in a private party who's sort of the conduit and ask them to do the work for you in terms of enforcing your property rights. And that's, you know, maybe in some cases that makes sense. But, you know, I actually think the DMCA notice and takedown is, again, like, as I said before, not great, but not so terrible that we might not figure out ways to make that a little bit better.
Yeah, and that is my objection. And you'll never hear me say that Congress should do nothing or that we should have no enforcement. In fact, we have very strong enforcement of copyright laws here. In a lot of cases, the laws for, you know, intellectual property crimes are far higher than for actual, you know, physical crimes to the person. So we have a very strong enforcement regime here. Again, it's about how do you get at the problem, and is there overbreadth and, you know, unintended or possibly even intended consequences to the internet? And in this bill, certainly there is.
We have a final question.
Just like to note that for the question of web streaming, you know, we all did come live to support the Federalist Society. There's been some discussion of global problems and regulations. I was wondering if the panelists had any views on the proposed anti-counterfeiting trade agreement, which would speak to some of the issues that were just discussed.
Well, I certainly do. I think due to the hard work of folks like Public Knowledge and others that we work with, other NGOs and other companies, the actual substance of the Anti-Counterfeiting Trade Agreement, or ACTA, is pretty benign at this point. There were a lot of really bad provisions along the lines that we were talking about that would have increased secondary liability, would have required, again, affirmative filtering or a so-called three strikes regime, and all that stuff is out of the trade agreement. That being said, the process by which this, and I'm going to put it in quotation marks, trade agreement came to be was really disgraceful. So there are international fora where IP agreements, treaties are debated with civil society participation and democratic processes. One of those things is called the World Intellectual Property Organization. But when things get democratic, things get and transparent, they slow down.
Mm-hmm. Yeah,
so let me just finish, Professor Epstein. So the proponents of this trade agreement went to USTR and said, we don't like WIPO anymore, let's have a trade agreement that's essentially an IP treaty. And that's what you have, and I am very concerned that this is going to be the way of the future, that all IP treaties are now going to be trade agreements. And if that's going to be the case, we've got to, you know, make USTR more transparent, more democratic. There need to be civil society groups on there, what the so-called ITACs, their advisory committees, IT advisory committees, international trade advisory committees. So we're going to have to change the whole process. When ACTA first started, we said, look, this is not a trade agreement, this is an IP treaty, you need to make it available for people to see. And they said, we don't do things that way, we have never done things that way. Well, that's changed because we basically beat the crap out of them. But I am very, very concerned about, you know, cloaking IP agreements under the cover and secrecy of trade agreements.
Yeah, just one observation, this is not by way of a disagreement, you'll be relieved, is international agreements are very high-risk endeavors. The advantage that you get out of them is uniformity. The problem you get out of them is uniformity. And what do I mean by that? Is that the disagreements are bad, but sometimes what you do is you get something which is uniformly awful as opposed to something which is merely chaotic. And therefore, you can't make an a priori judgment that you prefer one route after another. And what Gigi is saying, as I hear it, is that we had an open process by which we could do this through the IP for the World International whatever it is, patent WIPO, LIPO. And then you treat it as trade agreements, become secret bilateral kinds of arrangements. I think that's an extremely important thing to have to worry about, and I would put it in slightly different form. The same objection she made to the Lay Committee on Process with respect to the internal congressional stuff could apply also with respect to international kind of treaty obligations. And since there's no intellectual property that's actually at stake in these things, but just a framework, there's no reason that I can see for treating an international treaty as though it were trade secret, which is subject to confidentiality agreements. Certainly before it's adopted, it's got to be put. Transparency is sometimes a useful invention, and this is one such case.
As they say in the Supreme Court, time has expired, so
We
let's
lost our
thank our panel.